Good morning or good afternoon, wherever you may be in Australia, Asia, or elsewhere in the world. Um, Thank you so much for joining us. You're very welcome today. My name is Tim Lindsay, and I have the great privilege of being co-executive editor of the Australian Journal of Asian Law with Dr. Helen Pausaka, and I'm director of the Centre for Indonesian Law, Islam and Society, which is co-hosting today's launch of our special edition on law and people with disability in Asia. I want to begin by recognising the traditional custodians of the land on which the law school is located and other traditional custodians who may be the traditional owners of lands where you are located. In our case, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders, past, present and future. I just want to say a word about the Australian Journal of Asian Law, which is really the only journal of its kind in the world, a double peer-blind refereed journal. It's unlike many of the other journals of comparative law and international law that work on Asia. We don't publish international law and we don't do comparative law. What we do are the legal systems of the countries of Asia. And that makes this journal unique. We're very proud that we've been going for a quarter of a century now, 27 years to be precise. But more than that, we're very grateful to all the support we receive from our contributors over that quarter of a century. The journal would not exist without you. And that's why we're particularly lucky to have a selection of those contributors here with us today, the contributors to our special issue on people with disability and law in Asia. I want to also particularly thank the editors of this special edition, Dr. Dina Afrianti and Aya Webe. Both of them have put an enormous amount of work into preparing this special edition and, of course, into today's event. My thanks beforehand also go to my co-editor, Helen Pausaka, for all the work she put into the journal and today's event. And as always, to the manager of our centre, Catherine Taylor, who is going to keep us, I hope, online, happy, active and talking today. The topic of this special issue, I think, is one of the most important topics we've yet been able to cover. And I think the evidence of that is that we have 277 registrants who will be attending today's special launch seminar. And that is the largest turnout we've had for any of our special editions ever for the Australian Journal of Asian Law. And I think that says everything about how important today's topic is. So let's get started. What we're going to hear today are many of the contributors to this special edition talking about their papers, and they will be available for question and answer as well. There'll be a session after the presentations where questions can be put to the speakers in each session. Thank you once again for joining us. Congratulations to our special guest editors, Dina and Aya, and thanks also to all our contributors. Over to you, Helen.
Thank you, Tim. And I'll be chairing, so it's slightly different to the agenda. I'll be chairing the first session and Dina Afrianti will be chairing the second session. Each speaker will get 10 minutes and I'll give you a 3-minute notification when you're about to go. So our first speaker is going to be Aya, one of our co-editors, who will be giving the introduction to this seminar. So thank you very much, Aya.
Hello, everyone. I'm going to share my screen. Please just bear with me. Yes, hopefully you can all see that. Yeah. Thank you so much, everyone. First, I would like to thank Helen and Tim and Dina and everyone for this amazing opportunity to be a guest editor and to also co-author the introduction chapter. I'm very grateful for this opportunity. And today I'm going to be talking about the introduction and Dina will talk later on. First, I would also like to acknowledge the traditional owners of the land on we meet today. I'm coming from Unit W in Sydney, so from very good land, and I would like to pay my respect to the elders past and present. A little bit about me. So I was born in Sydney, Australia. I grew up with deafness. I have lived experience with disability myself. I went to high school that had hearing support unit. And in 2016, I completed my social research and policy honours degree at the University of New South Wales. From then, I have been working on so many different research projects, including at the Disability Research Team at the Social Policy Research Centre. Some of the projects that I've worked on include a review of the National Disability Strategy from 2010-2020. And I've also worked on so many different accessible reports, which was co-produced by other people with disability organizations and other resources from the SPRC. Some of the accessible reports include Easy Read English, Green Reader for people with vision impairment, videos in sign language, and captions. In 2019, I started my own research topic, which focuses on the identity and belonging of Muslim women in Sydney who are deaf or hard of hearing. Outside of this, I've worked in other community projects and research projects, offering advice, consultation, and I've done a lot of community advocacy work and a lot of volunteer work and trying to raise more awareness about disability, deafness, and diversity, especially in Sydney and other communities around Sydney and Australia. I do have some network to disability and deaf communities in Australia, as well as other countries like Indonesia, Malaysia, USA, and some Arab countries. I've also attended conferences in those countries, including South Korea a few years ago, where I presented at the World Federation of the Deaf, and I had to learn to present in sign language as well. Every time I go down to Indonesia, all the people there tell me that my name Ayah means father or dad in Indonesia. I had to explain to them in Arabic, which is my cultural background, my name Ayah means a sign or a miracle of God. So for example, when it comes to the Holy Quran, one ayah is one verse or one passage from the Holy Quran, but many verses is called ayat. And what's interesting in India, ayah means a nursemaid or a domestic caregiver. So I guess my point is language matters. And we were very aware that when it comes to understanding disability in different countries and cultures, there's different in translation and cultural interpretation. In consultation with the authors, we made sure to adopt a very inclusive language to uphold the human rights and dignity of all people with disability. Adopting a person-first language, people with disability was used mostly by government and non-government institutions in Australia where the special issue was published. Unless it's in a quotation or stated somewhere, person or people with disability were used as descriptive terms in this special edition to refer to individual or groups with all types of disability, including multiple disability. Attention and care were given to words, for example, vulnerable, needy, special needs, those people, and poor when it comes to identifying groups in order to avoid objectification of people with disability. So the author do talk about discriminative language in the articles and the different models of disability. Sometimes, for example, the shouting medical social or rights model, and how these models drive attitudes toward disability as well as the language used. A little bit of background about disability and law and in Asia. The United Nations Convention on the Rights of Persons with Disability, the CRPD, is the most widely ratified international human rights convention. It's a global framework for promoting the human rights and the dignity of people with disability, demonstrating a shared international commitment to advancing equality and inclusion. Australia ratified the CRPD in 2008, making it a legally binding international treaty with an all-of-government approach, from federal, state to local government. The National Disability Strategy, which I talked about before we did a review, and the new strategy called Australia Disability Strategy 2021 to 2031 are examples of Australia meeting the obligation. When it comes to Asia, in December 2022, the Economic and Social Commission for Asia and the Pacific, ESCAP, produced a report. Some of the comments from this report said, although there have been advances in disability inclusion over the last 30 years, the pledge to leave no one behind has not been achieved in this region. There is many ways to collect data about how many people with disability is in the region, but using the approach adopted by ESCAP, it can be estimated over 700 million people in Asia live with some form of disability. So this special issue provides insight into disability and law in 7 different countries. The countries are Hong Kong, Bhutan, Indonesia, Singapore, Malaysia, Philippines, and Bangladesh. Today, we're going to be hearing more from the amazing authors today, and they're going to be talking more about each country. Generally speaking, all states have very different cultural, religious traditions and differences in political systems. It might be assumed, given that all these countries have signed or ratified commitment to the CRPD, that the state parties and governments are willing and able to take necessary steps to ensure that the rights of people with disability can be achieved. Unfortunately, this is not the case in practice, as the article demonstrated. The authors also demonstrate that limited resources and lack of government commitment lead to failure to promote and protect the fulfillment of the rights of people with disability in each of the different states. The establishment of disability rights, perhaps in common with other areas of human rights, appears to face many cultural and systematic barriers and other issues. The article do reinforce that priority areas identified by ESCAP need to be understood and adopted. So this special issue invites reflection on specific examples of challenges and commonalities amongst them. Thank you so much, and looking forward to hearing more from all the other authors today. Thank you. If you have any questions, you can also contact me outside of the. Thanks.
Thank you very much, Aya. And in fact, you were well within time, which is extra good. I also want to remind speakers that we are having these talks interpreted, and we appreciate if you speak slowly rather than quickly, so it gives our interpreters time and their hands don't get too exhausted. So our next speaker will be Carol Peterson, and she'll be talking on disability rights in Hong Kong. Thank you, Carol.
Thank you so much, Helen. And I want to start by extending my thanks to everyone I've worked with in this project. The people who I've worked with on the journal have just been fabulous, and everyone who's worked on organizing this event has been wonderful. And I wish I could be there with you in person because I love Melbourne. But I'm here in sunny Hawaii. And I'm very glad to be part of this project. I think it's such an important project, and I've had the opportunity to read some of the articles now online, and I'm really learning a lot from everyone. So thank you. I am going to apologize in advance because I won't be able to stay on for the entire event due to some other issues, but I'm going to stay on as long as I can. The title of my article is Disability Rights in Hong Kong, Incomplete Progress and an Uncertain Future. And the first 2 sections of my article cover the incomplete progress, mainly focusing on Hong Kong's disability discrimination ordinance and what I think is a very inadequate enforcement model. And then I will also speak about the failure to reform Hong Kong's laws concerning the right to legal capacity. That will be the incomplete progress. The uncertain future will be, of course, talking about what's happened to Hong Kong since the enactment of the National Security Law in 2020 and the more recent enactment in 2024 of the National Security Ordinance. I do want to emphasize that Hong Kong is still a very wonderful city. I've been back many times since COVID and since the enactment of the National Security Ordinance and National Security Law. Some people think that human rights are completely gone in Hong Kong and that rule of law is gone in Hong Kong. I want to say that is not the case. It is still a wonderful city. However, there's no question it has changed. And there are huge restrictions now on freedom of expression and freedom of association. There is far less democracy in Hong Kong. We used to have at least partial local democracy Hong Kong. So there's no question it's changed, but I do think there's still scope for enforcing human rights in areas that do not conflict with Beijing's core interests. And my hope is that this is one area. So before I get into the enactment of the law, I want to tell you just a little bit about my background. Although I'm an American lawyer, I moved to Hong Kong in 1989, and I taught law there for 17 years, and I continue to go back regularly for research. When I moved to Hong Kong, it was a British colony, but the joint declaration, the Sino-British joint declaration, had been ratified. So everyone knew that Hong Kong was becoming a special administrative region of China in 1997. And so we called it the transition period because Hong Kong was transitioning from British colony to special administrative region. It was an amazing period in which to live in Hong Kong because law reform was happening everywhere and people were taking advantage of the increase in local democracy to advocate for stronger laws, particularly in areas like labor and human rights. A key event was June 4th, 1989, because prior to that, no one was talking about incorporating any international human rights treaty into Hong Kong's law. But after June 4th, 1989, when we had about 1 million people in the streets in Hong Kong, everyone said, we need a Bill of Rights. And the Hong Kong colonial government wisely copied the ICCPR, the International Covenant on Civil and Political Rights, because Beijing had already agreed in the Sino-British Joint Declaration that that treaty could continue to apply to Hong Kong. And as many of you may know, that treaty has never been ratified by mainland China, but it does apply to Hong Kong, and Hong Kong does report to the UN Human Rights Committee. So that enactment of the Bill of Rights Ordinance, which came into force in 1991, changed everything, especially in the equality movement, because women's organizations and other organizations saw an opportunity to advocate for their rights. Initially, an appointed legislator, but who was very committed to human rights and democracy, named Anna Wu, proposed an equal opportunities bill, which was based on Western Australian legislation. And I had the pleasure of working with her on trying to draft it. And an Australian academic, Andrew Burns, was on the team and very, very influential. We did get the bill introduced. It was much broader than what was enacted, but it helped to move things along because it made the government realize that they had to propose some compromise legislation in order to defeat Anna Wu's bill. And so the government proposed a sex discrimination ordinance and a disability discrimination ordinance. And at the time, I think that the law, which came into force in 1990, was enacted in 95 and came into force in 96. At the time, it was described by one international commentator as one of the most far-reaching laws for persons living with disability in Asia. And that was partly because it had influence from various jurisdictions, quite a bit of influence from Australia, actually. But of course, it wasn't perfect. And this was well before the Convention on the Rights of Persons with Disabilities. And so in that sense, it may not look like such a progressive law now, but I think for 1995, it was. As I've said in that section of my paper, in my opinion, the main problem has been the enforcement model. There was a real heavy emphasis on conciliation, and women's groups in particular fought for the right to sue directly, and they were successful in that all the anti-discrimination laws allow individual plaintiffs to file directly in the district court. And the law also provides that costs lie where they lie normally. So you don't have to worry that you'll have to pay the defendant's legal fees if you lose, which is normally the case in Hong Kong. However, litigation in Hong Kong is very expensive. And so most people have gone to the publicly funded Equal Opportunities Commission. It does have the power to assist with litigation, but the model discourages litigation because the statutes all say that the Equal Opportunities Commission has a duty to attempt to conciliate cases before even considering an application for legal assistance. And as I've explained in my paper, it naturally makes people too willing sometimes to give in and accept a very poor offer in a conciliation conference because they never know if they're going to get assistance to litigate until they failed to conciliate. And I've given a number of statistics in the paper that I won't go into that I think shows that the remedies have tended to be very meager in conciliation. They tend not to be systemic remedies. And therefore, I've also tried to focus on some of the cases where the EOC has litigated and has achieved some systemic remedies. And one of the ones I really feature is the case that was against the Hong Kong government.
3 minutes.
Thank you. A case called KYNW, where the Equal Opportunities gave legal assistance and successfully won a judicial review of a government policy that said we will not hire anyone in the disciplined services, and that's police, fire, immigration, customs, and anyone who wears a uniform, if they have a relative with mental illness. So think about that. Flat out, no hiring policy. The EOC was successful in that. I don't have time to go into the other cases, but in my opinion, if there was more litigation like that, and I think that disability rights groups have told me the same thing in interviews, they'd like to see more litigation so that they could see more systemic remedies. The thing I won't have much time to talk with you about tonight, just due to restrictions on time, is the problem with legal capacity. The mental health ordinance and all of the rules on adult guardianship have been dying for reform for so long in Hong Kong, and so many commentators have written about this. Most recently, Kelly Loper and I have published an article where we have argued that Hong Kong should follow the Irish model. It doesn't go so far as to implement General Comment 1 by the Committee on the Rights of Persons with Disabilities, but it would be a huge improvement, and I think it might be achievable. But we're not going anywhere right now, and this is where I will conclude. And the reason is that law reform is now stalled in Hong Kong. The Hong Kong government is focused on not much else than showing that they're really tough on national security. And we also have far less democracy in Hong Kong because so many people have been ruled unelectable by Beijing. They have to be patriots now, and the Legislative Council is far less representative of the general public. And on top of that, now the Hong Kong government is far less concerned about what human rights treaty monitoring bodies say. It used to be that they really liked it when they got perhaps some better comments than mainland China, and they would strive to respond to those comments and recommendations, at least some of them. But now we're really not seeing that. So that's why I call it uncertain future. I really hope that the disability rights movement can continue to advocate and be given the space to advocate, but it is a very delicate time now in Hong Kong. People have to be careful about what they say. But I do think that there are very committed people who are still working on human rights and equality issues in Hong Kong, and my hope is that we will be able to make more progress. Thank you very much. I hope I didn't go too much over.
Thank you, Carol. No, you didn't go over at all. I think you had 3 seconds to go. So our next speaker is going to be Stephen Rosenbaum, who's going to talk on Bhutan. So thank you very much, Stephen.
Thank you, Helen. I too want to acknowledge the traditional owners of the unceded land on which Melbourne Uni operates, and all the Indigenous nations and clans whose elders and knowledge holders have contributed to its reconciliation journey. I want to thank the AJAL and its editors and peer reviewers for a fantastic job in their review of the work and putting this together. And I want to thank the Auslan interpreters. I want to take a moment to express my critical outrage, in the words of a University of Maryland professor, Michael Millian, at the dissembling of our democratic institutions in the United States, notably the imperial presidency and its enabler, a partisan Supreme Court. And that's Supreme Court with a small s and a small c. In my article, it's based on my experience teaching a virtual disability law course in 2023 at Bhutan's recently established law school, the country's one and only. Disability inclusivity may be defined as more than the sum of its parts, and yet we often look to those parts in measuring success, whereas ESCAP, the UN Economic and Social Commission for Asia and the Pacific, uses a quantitative definition. Bhutan has its own indexing. The distinct Bhutanese calculus, part gross national happiness and human dignity, part Buddhist tradition and informal dispute resolution, and part reverence for a succession of benevolent kings. This has the potential to serve as its own platform for promoting inclusion. And in this article, I explore how a society might maintain its distinctive socio-legal culture and address issues of disability in a manner that may not be totally in sync with so-called Western or universal norms. Can the GNH, the Gross National Happiness rubric, offer a model? In answering this question, I examine an array of legal texts on the rights of people with disability and their access to justice. And along with ESCAP reports, the texts include the Bhutanese constitution, policies, reports, a series of assessments and indices, as well as international standards, principles, and guidelines, and a treaty, the treaty of which Carol Peterson spoke, and I believe Aya Webe did as well. By the way, I adopted the Australian Broadcasting Company nomenclature in my title, although, as Aya Webe alluded to, there is no unanimity about proper and nuanced naming as descriptors and identities have evolved over time, sometimes engendering great debate. Reasonable and even unreasonable people disagree on this question. I also, in my article, survey the pace of implementation and enforcement of the policies, a very important part of the article. The policies, practices, and philosophy, which are both local and universal. And finally, I scrutinize the disability clinical and doctrinal curriculum and teaching methodology offered at the country's only and relatively young law school. The scrutiny is practice-oriented and based in part on personal experience. And my observation is that policy drafters and law teachers appear to be working in siloed spaces, or what one veteran Bhutan commentator refers to as, quote, a bricolage of actors combining their individual experiences, needs, and desires, close quote, to form Bhutanese policy and, quote, the political realities of their country, rather than being uniformly coerced towards global norms and its isomorphic institutions. That may be a mouthful for our interpreter. By the way, I may be suppressing air quotes going forward in the interest of time, but it's not too, it's all there in the article, so I'm not misquoting or plagiarizing here. The potential is great for building a disability inclusive society in Bhutan on the foundation of a unique Bhutanese culture and developmental model, which in turn has Buddhist and pre-Buddhist roots. Some researchers suggest that the same developmental concept could be extended to the justice sector. Not a foreign idea, inclusion is built into the very cultural fabric of the ideals to which Bhutan hopes to aspire. That said, there is the risk that gross national happiness becomes a mantra or an advertisement for, again, what one commentator calls the Shangri-La of development, without making the right real. I think that's the phrase we heard Aya Webe speak about, making the right real in the lingo of the Incheon strategy, that is, without promoting real change. The Incheon strategy having been developed in Incheon, South Korea, at a conference of a regional conference. When ESCAP membership proclaimed the regional decade of persons with disabilities in Incheon, it adopted the colloquial branded strategy, which includes 10 disability-specific development goals and multiple targets and indicators. Now, dismantling an ableist history and environment is a process that is about ensuring wheelchair access, sign language, visual aids or cues, including large font size, awareness raising, and a variety of accommodations. But it is also about transcending objectification, thinking critically, and cultivating dignity. Aware of my outsider status, I wrote this piece with empathy and humility, but also with candor. I aimed to be reflective and mindful of my status as a non-Bhutanese observer and the potential negative impact of replacing indigenous legal values with those that are neo-colonial, globalized, or modern. I'm going to, for the moment, dispense with my discussion about gross national happiness unless Helen allows me to take time others have ceded. I'm going to put that aside in the interest of giving you my conclusion. Then I will come back to the GNH and the teaching itself, time permitting. So what I concluded in my article is that first, policymakers, technocrats, scholars, religious leaders, and educators should continue to embrace the kingdom's rich spiritual heritage, legal culture, and history. The unique concepts of happiness, dignity, and fair and equal treatment are a foundation on which to lay international obligations and best practices in fostering the full participation and accommodation of its disabled citizens in all aspects of life. Now, this includes use of traditional informal means for dispute resolution, and relying on a reverence for the influential role played by the monarchy in the justice system. Second, words matter. There is a wealth of literature about GNH indexing and its relationship to law, including its place in the Constitution, but often there are only perfunctory references to this uniquely Bhutanese fundamental developmental concept, and drafters and scholars do not always pay attention to the labors of colleagues and commentators. Rather than starting from the ground up with each new assessment or initiative, they could reflect on and refine the language of laws, policies, and findings made to date about disability and people with disability. Third, and relatedly, legal text must be translated into reality. This recognition, in line with Inchan's strategy goals, has been reiterated in a number of Bhutanese studies and initiatives. Making the right real applies as well to less abstract mandates or hortatory language about awareness raising, sensitivity training, networking, coordination, and resource mobilization. As noted in the recently executed National Assessment on Access for Justice for Persons with Disabilities, another mouthful, the relevant stakeholders need to be sure that all relevant policies and guidelines, both at the national and international levels, are appropriately converted into practice because, quote, as a GNH nation, it is the responsibility of all individuals to support each other and make sure that no one is left behind, close quote. Again, you heard from Aya Webe on that particular line, no one is left behind. Finally, I conclude that it is important to educate the country's future lawyers, judges, and civic leaders in the knowledge and application of international principles of disability human rights and non-ableist, non-hierarchical practices, together with Bhutanese concepts such as human dignity and gross national happiness. In its drive to be an incubator of innovation, the law school's faculty and staff must be wary of some of the lapses in legislation, policymaking, and practices that I discussed above. Course design and instruction can also suffer from glib references, overlooked texts, disregard of traditional justice forums, and siloed policy construction, as in the words of a veteran commentator of Bhutan. The leadership at the country's only law school talks the talk of infusing the GNH principle and Buddhist and universal human values in its instructional programs and research agenda, but the president herself is a member of the venerated royal family, committed to the staples of Anglo-American and European legal education, as well as Bhutanese values and methods. But the time may also be right to accept the invitation from the founding faculty members to develop a, quote, corollary justice framework, another phrase we heard from some of the commentators, if it's not already been undertaken, which I was not able to learn in the process of writing my article. This is supposed to be a conversation with key justice sector stakeholders and international colleagues. And much as the Gross National Happiness Index is used to inform potential legal reforms and innovations, such a framework could assist in screening potential new policies while remaining mindful of, quote, culturally grounded development pathways, end quote. And again, I've come out ahead, I think, on my time, and will use any time if people are interested in question and answers on a further discussion of gross national happiness and also the curriculum at the nation's law school. Thank you very much.
Thank you very much, Stephen, and for keeping well within time. And yes, we can use the time in question time. So our next speaker is Dina Afriyanti, and Dina is also one of the co-editors together with Aya. But on this occasion, Aya has spoken for Dina and herself, and Dina will be speaking for herself and Stuart Fenwick, who could not be here. So Dina will be speaking on disability, religion and citizenship in Indonesia. Thank you very much, Dina.
Thanks, Helen. Good afternoon, everyone, and thank you for joining us today. As one of the guest editors for this special edition, I would like to also sincerely thank the AGAL for the initiative in organizing a special issue on disability and the law in Asia. I must say that when I accept accepted the invitation. I thought this is a rare and important opportunity. Disability studies have too often been marginalized, especially probably I'm speaking in the context of Indonesia, within the mainstream academic discourse, particularly in legal scholarship. By placing disability at the center of this edition, Aya and we spoke about this. This is not only going to broaden the conversation, but also affirms the value of inclusive intersectional inquiry in understanding disability law and society. I would also like to thank our Auslan interpreters today. Apologies that my co-author, Dr. Stuart Fennick, cannot be with us today. Before I start, I would like to begin by acknowledging the traditional owners of the land on which I'm speaking today, the Wurundjeri people of the Kulin Nation. I pay my respects to their elders past, present, and emerging. I acknowledge the sovereignty and the ongoing custodianship of the First Nation peoples of this country. That sovereignty was never ceded, and this always will always be Aboriginal land. So our paper, Disability, Religion, and Citizenship in Indonesia, draws on both our academic research and many years of advocacy work with people with disability in Indonesia. This project began with a fundamental frustration, I must say, that despite witnessing years of work that disability advocates in Indonesia have made and significant legal progress, including Indonesia's ratification of CRPD and the introduction of national disability law in 2016, and also introduction of many regulations, many people with disability still face systemic discrimination and also exclusion. So the research also seeks to contribute to the extensive work on religion and equality in Indonesia. Religion has at times served as a brake to social inclusion. Religious chauvinism has restricted religious diversity and also continues to prove challenging for the advancement of human rights in Indonesia, such as women's rights, the rights of people with disability, and also minority rights. So we essentially ask if a focus on the rights of individuals as citizens in a society can help to overcome the limitations sometimes faced by rights-based advocacy. So I start with Indonesia policy progress. Indonesia has established a solid framework of national and also regional policies, including regulations around education, employment, housing, and also healthcare. However, real implementation of these commitments remains elusive. People with disability continue to encounter discrimination to access schools, for example, from primary or even like child care services to higher education. They are unable to join formal employment due to job market discrimination and also experience limited mobility because of inaccessibility of infrastructure and also public services. All of this is due to the mindset among policymakers, as our previous speakers have also elaborated, and also among the service providers, which hasn't changed fast enough. The prevailing perception is still that persons with disability are recipients of welfare or object of charity rather than equal citizens with full rights, as enshrined in the CRPD. So this is the disconnection that I often encounter in our research between legal obligations and the lived realities. And it is really the starting point of our inquiry. My co-author and I have worked on the role of religion in Indonesia, so we often discuss about what is the role of religion in disability advocacy. We frequently ask the question, is it a source of empowerment or to the contrary, a site of further discrimination? The question arises as we often wonder about what actually blocks the implementation of disability rights in Indonesia. And of course, one of the comments that always comes to our mind is, could it be religion? And as we ponder, we identify that the challenge for the realization of rights can be multi-layered and actually are multi-layered. So they include the bureaucratic inertia. This one is the most persistent challenges. I think Stephen talked about this as well in relation to the what happened in Bhutan. Although legal framework exists, the implementation is slow and also fragmented. The multi-sectoral nature of disability is frequently misunderstood, or sometimes I thought perhaps they don't understand it at all. Second one is about the cultural and also social attitudes. So even where policies exist, social perception can be far more resistant to change. Disability is still viewed by many as a result of sin or shame. Our previous research indicates certain traditions within the Islamic community perceive disability as either a blessing or a sin. And we also see the similar perception persist in other religious traditions. The third one is about religious interpretations. While Islam and Christianity do not inherently discriminate, long-standing interpretations have reinforced ableism and through charity-based or exclusionary approaches. So we wanted to dig deeper into these cultural and normative dimensions through this project. And to do that, we thought that perhaps citizenship can be explored and examined and might function as a unifying concept in the context of Indonesia. So we are inspired by the work of Martha Nussbaum and also Iris Marion Young. And we argued that full citizenship must mean more than just legal identity. It must mean agency, visibility, and also participation. So we first tried to find what citizenship means by reference to both Australian and also Indonesian law. As we explore in our paper, citizenship in our laws,
3 minutes.
the dual nature it is considered to have in academic and also philosophical writing. That is, in addition to the legal status within a society, citizenship also embraces a sense of civic belonging. Too often, people with disabilities are denied both. The idea of equal citizenship becomes rhetorical when religious teachings or institutional practices still frame them as dependent or excluded. Through our research, we start thinking that religious thought or faith-based framework can also be a tool for inclusion. We look at Islamic and Christian disability theology. Within Islam, jurisprudence like fikih disabilitas in Indonesia or disability fiqh is beginning to emerge, emphasizing compassion, dignity, and the right to worship. Christian theology, based on the powerful work of Nancy Island, who proposed the concept of the disabled God, also calls for a radical reimagining of inclusion, not just in physical spaces, but in symbols, language, and community belonging. Given that the majority of Indonesians are deeply religious, and that time and again we see how religion continues to shape both public attitudes and also national policy making, we expect that this conversation will urge policymakers, religious leaders, and communities to use these frameworks not to exclude, but to transform inclusion into a shared moral and civic responsibility. So in conclusion, achieving the rights of people with disability in Indonesia is not only a legal challenge, but we think it's also a cultural one. By applying a citizenship lens and drawing on inclusive religious teachings, we think that perhaps we can encourage and promote the need to eradicate the framing of disability as a deficit, but to encourage the community, in particular policymakers, to treat disability as part of human diversity. And so we hope that through this paper, we help shape not only policy conversations, but also the hearts and minds of those who shape Indonesian public policy. Thank you.
Thank you very much, Gina. And also you, like everybody else, has been very good in keeping with time. Now we're going to have a short break. and we will convene back in 3 minutes or so at 3 o'clock. And Dina will be our, what do you call it? Our chair after that. Thank you.
Thanks, everyone. There was a very short brief, but hopefully it's enough for you to do whatever you need to do. So we are going to listen to 4 authors who are going to share with us their contribution to the spatial journal. So first of all, I would like to call Meng Yi Wong. I apologize if I pronounce your name incorrectly. So Wong, I apologize. Probably we can go to the next one until you can, you sort out what's wrong with your speaker probably. So I'm sorry about that. So now we would like to invite Hanira binti Hanafi and also Nur Hidayah binti Abdullah, who is going to share with us about financial inclusion, policies and challenges for people with disability in Malaysia. Time is yours.
Okay, thank you so much, Mr. Chairwoman, for today. First of all, I would like to extend my gratitude and extend my, I feel very fortunate to be part of the team, particularly to contribute to this special issues on the disability in Asia. Okay, today's presentation will be made by me, myself, and my co-author, Dr. Hidayah. And I'll start the presentation first. Okay, Dr. Hidayah, can you share the slide, please? Okay, thank you very much, Catherine. Okay, okay, I would like to maybe say something about the background, maybe. Okay. Just straightforward that I would share the abstract about our article. This article is actually to explore the challenges of promoting inclusivity financing among people with disabilities in Malaysia using the secondary data and the semi-structured interview where we got the findings from the bank regulators and also the NGOs or non-government organization which take care of the PWDs people. Okay. Nevertheless, current study shows that while access to financial services for persons with disability remain limited, but it's in fact gradually improving, okay? Gradually improving. And it finds that the barriers faced by the banking institution in delivering sound financial services to BWDs relate to the high cost of infrastructure and facility, default risk, barriers in communication and understanding, poor financial and product literacy, and non-user-friendly digital banking system. Okay, this is actually the general policy on PWDs in Malaysia. Okay, in fact, Malaysia is already ratified the United Nations Convention on Rights of Disabled Persons in 2007, and to give the and then Malaysia have the national agenda, national policy on PWDs back in 2008. But in order to give the legal effect to that, Malaysia further passed through the parliament, passed the act, we call it as the Person with Disabilities Act, where the act focuses on the registration, protection, rehabilitation, development, and well-being of the individuals with disabilities. Okay, and the act is also providing the rights to accessibility for people with disability, and the accessibility includes, for example, the public amenities, the public transport, for the buildings, education, employment, health, and also and more. Okay. However, in terms of the Person with Disabilities Act itself, even though there is the legal right conferred to the people with disability to enjoy the accessibility, to enjoy the same right as the normal people, however, in that particular act itself, it doesn't have the provision providing remedies for their breach, meaning that if the right is denied, they have no provision to bring that case before the court using this particular statute. Okay, can we move to Yeah. And this is the general purview of the legislation in Malaysia. And we can move focus with the financial inclusion. Okay, the financial inclusion in Malaysia is meant that to ensure that all people can access to the financial, to the financial in Malaysia. Okay, with that, financial inclusion has been introduced by the government through the financial sector blueprint 2022 until 26. And on the institutional level, the Central Bank of Malaysia is responsible to issue the Financial Inclusion Framework 2023 until 2026. Okay, but in the Malaysia Central Bank Act itself, it does not contain any specific definition for the financial inclusion. But with the issuance of the Financial Inclusion Framework 2023, there is also the policy document that the Central Bank of Malaysia issued. We name it as the Fair Treatment for Financial Customers, were issued by the Central Bank of Malaysia, where the purpose is to provide additional guidance and regulatory requirement to ensure that financially disadvantaged consumer receive fair treatment. When we talk about the disadvantaged consumer, it does not only confine to the people with disability, because it also includes the elderly and so on and so forth. Okay, and then can we move to the third slide? Okay, as such, what I can say, we already have the statute in place in Malaysia to accommodate the need of the people with disabilities. We recognize their rights through our statute. We have the specific statute on people with disabilities 2008. And in terms of the financial inclusion, we did have specific blueprint to accommodate their needs in terms of the financial inclusion. And the central bank also introduced the fair treatment policy document for those people to be treated fair when dealing with the financial institution. But according to the interviews that we made with the bankers and also with the NGOs, we found there are several issues related surrounding with the people with disabilities in Malaysia. Number one is because of the high cost of infrastructure and the facilities. Okay, because we know that the modification of physical facilities requires higher costs, because at the first place, the building is not established. It's not, we don't build that building with the aim to accommodate the PWDs, but later we should do the modification, and of course it requires higher costs. Therefore, it will delay the right of the people with disability to get access successfully, smoothly to get access with the financial provider.
You
okay,
have
however,
3 more minutes.
Okay, thank you. Financial inclusion now may opt to the utilization rather than physical facilities to encourage inclusiveness. And then one of the other issue is that the default risk, because PWDs are normally labeled as the people who cannot, with the low income and under the poverty line, therefore they are not unbankable. So they are unbankable. So this is also the issue. And please, Dr. Hidayah, please continue.
All right. Thank you, Hanira. I'll continue the following challenges. Yeah. So the next challenge is on the preference for conventional over Islamic banking service. As you know, in Malaysia, they operate dual banking system. Yeah. So customer can choose either conventional or Islamic banking services. Yeah. But it found out that the PWD, person with disability from B40 and M40, would prefer to go to conventional banking system. This is because the perception that is the conventional is cheaper as compared to the Islamic banking. Yeah. Now, and then you can see the officer is also did not have knowledge or inadequate about this product. So that's why they prefer or encourage the PWD to go to conventional, even though the Islamic banking provides a long-term repayment stability. Right, next. Can I add a few? Yeah. And then next, the challenges is about on low financial literacy and lack of communications. Yeah. Because as you know, in Malaysia, people with disability have a low financial literacy because they are not well educated. Yeah. And bank staff also, they do not have received any training. So it's hard for them to explain to the PLPD about the product in Malaysia. The last one, okay, next. In the absence of user-friendly digital banking system, yeah, because most Malaysian digital banking did not follow the Universal Design or WTC, that is worldwide consortium. Yeah, so there's a problem on.
You have 30 seconds left.
All right, and then without mandated enforcement or dedicated accessible team, banks treat digital accessibility as an optional. Next, right. Next slide. Recommendation. So these are a few recommendations that
yeah, because your time is almost up. Sorry about that.
Oh, okay.
Maybe you can go to conclusion.
All right, conclusions. All right, thank you. Okay, all right. So as general, there are several legislation related to PWD which aim to promote their rights and inclusivity. However, there are no remedy provision for their breach. So the Central Bank of Malaysia also promoting financial inclusion through a combination of government initiative and issue of regulations and policy, right? Right, to guarantee that financial institutions are properly adhering to the current policy on PWD, federal and state government should expand their official oversight of matters pertaining to financial inclusion. That is our recommendation on this issue. Thank you.
Thank you so much for both speakers. I'm so sorry with the technical difficulties we had early on. So now probably I can check with Mo Wong as our next speaker.
I don't think he's back yet, Dina.
All right. Okay. So probably now it's time for us to invite Zanina U Custodio, who is going to speak about Mind the Gap, bridging the divide between designing and implementing inclusion policies in the Philippines. Similar with others, you have 10 minutes from now. Thank you.
Good afternoon. Please confirm if you're seeing my screen.
Yeah.
Okay, thank you so much. Mabuhay, I'm Shanina Yogustodio, and I'm honored to present my paper, Mind the Gap, Bridging the Divide Between Designing and Implementing Inclusion Policies in the Philippines. Before I continue, I'd like to respectfully acknowledge Indigenous peoples of the Philippines, especially the Tagalog ancestral stewards of the land where Philippine Normal University stands. I honor many Indigenous communities across our archipelago whose deep connection to land, culture, and community continues to shape the nation's heritage. As I speak today about bridging the gap in inclusive identity, I recognize that true inclusion must also involve acknowledging the historical and ongoing exclusion of Indigenous voices. May our work in education contribute to justice, not just in policy, but also in practice. I am supposed to click this, okay. So inclusive education is more than just physical access to schools. It reflects a deeper commitment to building an educational system where every learner, regardless of ability, background, or circumstance, can participate meaningfully and succeed. UNESCO 2023 frames inclusive education as a process of strengthening the capacity of the education system to reach all learners. The Philippines is echoed with this vision through various laws. Yet, despite this progressive legal architecture, a persistent implementation gap remains. one that challenges our ability to translate policy commitments into practical outcomes. To uncover the reasons behind the policy practice divide, the research employed a qualitative methodology. This included document and literature analysis, as well as comparative and historical approaches, strategies well regarded for exploring complex educational phenomena. The analysis spans from the American colonial era through the pre-Salamanca period to post-Salamanca developments and current trends. The historical arc reveals not only how inclusive education evolved in the Philippines, but how, in some areas, it has failed to progress meaningfully. There's no on the screen, but even before the 1994 Salamanca Statement, the Philippine Constitution and Magna Carta for disabled persons guaranteed access to quality education for all learners, including those with disabilities. Salamanca was pivotal. It positioned inclusive education as a fundamental human right. In response, the Philippines enacted reforms such as Deputy Order 11 Series of 2000 recognizing SPED centers. We have RA 10533, Enhanced Basic Education Act, and then the Philippine Professional Standards for teachers all laid groundwork for inclusive practices. Most notably here, we have RA 11650, which mandates that learners with disabilities be included in the general education classrooms. It institutionalized individualized education plan and established inclusive learning resource centers, or what we call as ILRC, to support both learners and their families. While this legal framework is comprehensive, the research reveals that on-the-ground realities remain fragmented, limiting the policy's effectiveness. So why are inclusive education policies not translating into inclusive practice? One major reason is the uneven implementation across the country's 17 regions in more than 7,000 islands. While some local governments actively support inclusive education, others allocate no budget at all for all learners with disabilities. The decentralized nature of Philippine governance without corresponding accountability mechanisms has led to stark regional disparities in access and quality. Capacity gaps also undermine implementation. Many teachers are not adequately trained to support learners with disabilities, particularly in using differentiated instruction, universal design, or developing IEPs. While RA 11650 and RA 10533, for instance, mandate the use of Filipino Sign Language and inclusive strategies, few teachers are proficient. There is also a significant shortage of special education teachers, specialized learning materials, and flexible curricula. Moreover, weak collaboration among teachers, families, and communities makes it difficult to identify learners' needs early, undermining the very foundation of inclusive education. Poverty deepens these challenges. Learners with disabilities from low-income households face higher dropout rates, lower achievement, and frequent school absences. UNICEF 2022 notes that families with children with disabilities face poverty rates at least 50% higher than the general population. So schools are often ill-equipped, lacking accessible restrooms, ramps, and elevators. Financial constraints further limit assistive devices, therapies, and trained support personnel. Is my time over? So this intersection of disability and poverty highlights the urgency of targeted equity-driven interventions. Now, these are not isolated issues. I would say that these are systemic. Inclusive education lacks a dedicated funding stream, and pre-service and in-service teacher training remains limited. So monitoring and evaluation systems are fragmented, making it difficult to track the progress of our learners with disabilities, or just simply assess the program effectiveness. So worse, we have negative social attitudes and deep-seated discrimination, which continue to isolate learners with disabilities, both academically and socially. So to further understand these challenges, the study draws on Michael Lipsky's theory of street-level bureaucracy. According to the framework, local actors, such as that of teachers and school heads, exercise discretionary power in policy implementation. Some may deny enrollment due to a lack of resources. Others, with more initiative or support, find creative ways to include learners despite constraints. So the variation creates unequal learning opportunities, which collectively hinder the realization of inclusive education. So this brings us to a critical question. How can inclusive education policies move beyond symbolic commitments and become enforceable, lived realities of all children? This brings me to propose several actionable recommendations, such as establishing clear roles and responsibilities among government agencies to prevent overlap and ensure cohesive implementation of inclusive education policies. Second is to strengthen the capacity of local government units in budgeting and inclusive planning to ensure resources are effectively allocated to support inclusive education. Third is to integrate comprehensive training on disability rights and inclusive pedagogies into teacher education programs to equip educators with the necessary skills and attitudes. Finally, develop robust data collection systems to monitor the programs of inclusive education and foster active engagement with communities to support learners with disabilities. Hence, the goal is actually not simply policy alignment, but we have to goal or to aim for policy justice. Inclusion must move beyond aspirational language and become a lived, enforceable right for every child, regardless of disability, geographical location, or socioeconomic status. So we are continuously trying to move from policy intent to policy justice grounded on equity, empathy, and accountability. And only then we can truly transform inclusive education from a distant aspiration into lived, empowering reality for all of our learners. Thank you so much.
Thank you so much, Zanina. You are way ahead of your time, so you still have actually 1 more minutes, but thank you so much. So I would like now to check if Meng E. Wong is already here with us. Meng?
He is here now.
All right, okay.
Hello, I'm here, and I hope you can hear me.
That's perfect.
Okay. Apologies for the technical hiccups. Well, thank you again to the AJAL for pulling this important issue together, and very happy to have had the opportunity to publish. I want to thank the editors, the reviewers for helping to sharpen the article and putting it into a publishable piece. I will dive into my presentation. Okay, so my name is Meng E. Wong. I'm from the National Institute of Education at the Nanyang Technological University in Singapore. It's my privilege to be here to share with you this article. The article is a review of the Enabling Master Plan in Singapore, and the objective here is to consider legislation for disability-led anti-discrimination laws or legislation to be put in place as a proposal. So maybe before I start with the overview here with the Enabling Master Plan, I should say that in Singapore, we do not have any legislation as such that is that supports disability rights or anti-discrimination of that nature. The closest we've had in Singapore was in 1988, where we had the Advisory Council on the Disabled, which was convened by the then Prime Minister to consider how persons with disabilities could be better integrated into society. So one of the key outcomes of that that report was the broad agreement that persons with disabilities should be integrated wherever possible, and they have the rights to do so as a citizen of Singapore. Now, bear in mind that was in 1988. and that was a report with a series of multiple recommendations. So pretty much in Singapore, the practice is mandated by policy and recommendations in the preceding period post 1988. Now we come to this, the enabling master plan, which comes in four different iterations. The first one was in 2007 to 2011, and 2016 to 2020, and 2020 to 2022. So the current one is from 2023 to 2030. So we're breaking away from tradition, as it were. Instead of every 4 years, the enabling master plan is refreshed and reintroduced with different emphasis. This current one that is ongoing is stretched right till to 2030. Within each of these master plans, there are emphasis of how to improve inclusion practices in Singapore. So these are policy recommendations put forward to the government. They broadly are accepted and supported, and is what would you call a roadmap, a national roadmap for inclusive practices in Singapore. I will focus for this paper only on employment, education, and public education. But it covers quite an expansive range of issues with regards support for persons with disabilities. I should also add that in looking at this, I drew a little from Charles Lingdom's work on incrementalism, and that's really the focus on looking in terms of public policy. How does policy public policy work in incremental steps to support change and to support advancements for different types of public policy. So in this particular case, we would say that the government has deliberately taken an incremental approach in supporting disability policy work. Charles Lingdom calls it the science of muddling on, and probably quite rightly so, because his argument is that it's very difficult to prognosticate the future without adequate understanding and focus on what is to come. So it falls in nicely with the argument for an incremental approach to disability policy making, taking a step-by-step approach, being flexible, and moving along with this governance approach in policy making. Now, looking at the three broad areas and focusing firstly on education, we could see across the enabling master plans from 2007 and the ensuing 4 iterations, we see a pattern of small policy recommendations, and this can start with having more schools, having teachers be better trained, having recommended curriculum models, etc. And this is consistently have been built up across the 4 enabling master plans. The focus if we look back now, the focus was really to match the provisions in order to be able to support compulsory education Now, the Compulsory Education Act was introduced in, was debated and passed in law in 2000. It was enacted in 2003. But the interesting point to note here for Singapore, students with disabilities were only brought under the Compulsory Education Act in 2019. So we could make a case here to say that some of these enabling master plan recommendations for education, it took them 19 years, 18, 19 years in order to prepare for the curriculum, for schools, for infrastructure to be ready in order to make compulsory education supportive to include students with disabilities. The other big area is employment. And again, over the 4 iterations of the enabling master plan, we see the incremental recommendations on how do we increase better employment opportunities for persons with disabilities. So this could have included having recommendations for greater and inclusive employer networks to be built, open door funds, employment credit, and we see these policy recommendations happening throughout the span of the enabling master plans. The Singapore government continues to take a business case for recommending hiring persons with disabilities.
We have 3 more minutes.
Thank you. Thank you. Okay, I will move on quickly, just to cover this. Public education is the other broad area, and again we see recommendations for many efforts towards strengthening public education, for example, volunteer management, and having many more public campaigns to push the agenda. So you see a few public campaigns there. See the True Me, Unawkward Me. These are 2 national campaigns that have come and gone. The question is, what happens after the campaigns? Are these sustainable enough to make change? So a couple broad policy considerations. We see so far that the enabling master plan takes a bit of a top-down approach to policy making for persons with disabilities. With the enabling master plan, we could say that there's no legal enforceability. There's a lot of reliance on goodwill. We had ratified the United Nations Conventions on the Rights of Persons with Disabilities, the CRPD, in 2013. But we don't see very much of it in terms of a domestic incorporation within the laws. So we could argue that the enabling master plan is the front-facing version of the UNCRPD in Singapore. So beginning to say that yes, incremental approaches are helpful, but perhaps we need something larger, as in legislation, to pull it together in order to make disability policy a lot more effective. So in conclusion, the enabling master plans, I would say it's important, it offers vision, but it may lack a binding power to move forward. Legislation is an important part and has a place and helps to protect disability rights. It also will tie up nicely with the UNCRPD and how that can be better blended into local domestic laws. And I think the conclusion here, would like to argue, is that we need not only policy making, but we could have greater legislative integration. Thank you.
Thank you so much, Meng. You made it on time.
Thank you. Thank you.
Now we are going to have our last is I would like to call our speaker Asma bin Safik, who is going to talk about her research in Bangladesh towards achieving sustainable substantive equality, a critical overview of disability law in Bangladesh. Now, I would like to invite everyone, if you have any question, you could start writing in the Q&A chat box, and then we will going to try to accommodate that during our Q&A. Time is yours, Asma.
How is it
Maybe
now?
check the
Yeah,
volume. Yeah, that's good.
Yeah.
Sorry.
All right.
Thanks, Tina. Thank you very much. It's great to be part of this online launching. Let me begin with sharing my slide. I hope it goes well. Most morning on the way to my classroom, I encounter a woman who travels to law school to help her son with a mobility impairment get into the classroom. She has to wait a long hour until the lectures are complete to take her son back home. The mother's struggle in providing education to her son is common to many Bangladeshi parents who have children with a similar disability. Their struggle is associated with the fact that most buildings, including educational institutions, are not accessible to their children. Roads and footpaths that are crucial to accommodate people with mobility impairments are also hard to find in Bangladesh. Such a situation continues despite the presence of positive laws on people with disability. Although these people represent one of the most disadvantaged sections in Bangladesh, the existing literature on equality and non-discrimination hardly concentrate on them. My paper, entitled Towards Achieving Substantive Equality, a critical overview of the disability law in Bangladesh, examines to what extent the disability law in Bangladesh responds to the substantive equality rights of people with disability. It does so by drawing on a conceptual model of substantive equality prescribed by Sandra Friedman. First of all, I am going to talk about what constitutes the disability.
Yeah,
Can you hear? Okay, thank you. So the disability law of Bangladesh is based on a legislation called the Rights and Protection of Persons with Disabilities Act 2013, which I will mention as the RPPD Act later. Along with this act, the provisions of equality and...
You're freezing.
Is it okay now?
No, yes.
Sorry, I'm sorry about that. This
right.
is also an infrastructure issue in Bangladesh.
Yeah, that's fine.
Yeah.
You?
The provisions of equality and non-discrimination under the Constitution of Bangladesh and relevant provisions of some other pieces of legislation represent the national legal framework on persons with disability. These legislative and constitutional provisions provide a strong theoretical underpinning for the protection of rights of people with disability. For example, although the equality provisions of the Constitution do not mention disability, they can be interpreted to guarantee the rights of people with disability. Other legislation explain how the rights of persons with intellectual disability to access to justice can be ensured. The RPPD Act broadens the scope of these legal provisions to address the claims of people with disability. The Act contains specific provisions on the rights of persons with disability that the Constitution and other laws lack. For example, the RPPD Act guarantees several rights to people with disability, which include the rights to proper healthcare service, the use of the Bangla Sign Language, accessibility to the community, transportation, education, and training, and discrimination-free employment opportunities. These provisions are likely to promote the concept of reasonable accommodation and contribute to improving the position of people with disability. Although the provisions I have mentioned echo the features of substantive equality, they do not ensure the human rights of people with disability in practice because of some limitations of the disability law. The disability laws more emphasize on formal equality than substantive equality remains one of the fundamental weaknesses. Moreover, since the Constitution does not expressly recognize disability as a ground of discrimination, the equality claims of people with disability fail to receive the required attention. A major problem of the RPPD Act is that it has not prescribed a timeline to achieve its goals. Further, it has not set standards against which these people could claim their rights in the context of Bangladesh. Other weaknesses of the Act, as I explained in my paper, further hampered the implementation of the rights of people with disability. Therefore, I argue that despite the RPPD Act's recognition of specific rights of persons with disability, it has failed to play a substantial role in ensuring these rights. So I suggest that the concept of substantive equality should be properly engaged with the national framework to guarantee the protection of the rights of persons with disability in Bangladesh. To accommodate the substantive equality rights of persons with disability within the national framework in Bangladesh, I have relied on the concept of a four-dimensional model of substantive equality. The four dimensions are the redistributive dimensions, which deal with breaking the cycle of disadvantage, the recognition dimension, emphasizing the promotion of respect for equal dignity, the transformative dimension, affirming community and identities, and the participative dimension, Now I'm going to explain why I have suggested the adoption of this model. The model's potential to focus on the practical implication of substantive equality, going beyond its theoretical aspects, encourages me to adopt the four-dimensional model. It might be asked how Friedman's conceptual model, a product of Western scholarship, could be relevant to Bangladesh. My response is that I have relied on the basic principles of substantive equality suggested by Friedman rather than the context in which they have been developed. These principles, such as addressing disadvantage, addressing stigma, and accommodating difference, are achievable in any society irrespective of its nature. What is required is that every society should endeavor to attain them by considering its own context. I have explained in the later part of my article how the legal system of Bangladesh could do so. Another significant aspect of Friedman's concept of substantive equality is that its features are reflected in most human rights instruments. An analysis of different human rights instruments reveals that various provisions of human rights treaties and interpretation of the treaty monitoring bodies resemble the feature of substantive equality discussed by Friedman. In my article, I have explained how these human rights instruments promote the features of four-dimensional model of substantive equality, from breaking the cycle of disadvantage to participation. Since Bangladesh is a party to these instruments, it is under an obligation to promote these features. The question is how the disability law in Bangladesh responds to this obligation in practice. As I have already mentioned, people with disability face immense challenges in enjoying their rights in Bangladesh. In addition to the challenges related to the legal framework, Negative social attitude towards people with disability constitute a significant obstruction to the protection of their rights. Such an attitude towards these people is not uncommon in many societies, but is deeply rooted in Bangladesh and similarly situated countries with a conservative social structure. The negative attitude encourages prejudices against children with disability that gradually exclude them from society. The state's failure to develop the capability of people with disability through ensuring reasonable accommodation, inclusive education, and other facilities create further challenges. Lack of funds remains a significant factor behind this failure. So how Bangladesh respond to these challenges to ensure the rights of persons with disability?
With one minute to go.
Okay, so since the shortcomings of the socio-legal structure are mainly responsible for the denial of disability rights, reforms should be initiated in the required legal and social fields. The success of such reform would depend on how creatively the state addresses a range of factors related to the promotion of substantive equality. Such reforms will play a significant role in making human rights meaningful to people with disability in Bangladesh. Thank you.
Thank you
Thank
so
you very
much.
much.
Thank you, Asma. You're making it on time. Okay, now I leave the floor to Helen.
Okay, thank you very much, Dina, and I'll be very quick, but it's essential I speak now because I want to thank all of the speakers and authors for the issue. That's Aya, Carol, Stephen, Dina, Meng E, Hanira, and Nuhidaya, Zanina, and Asma. And thank you all very much for participating. I also want to thank our Auslan interpreters, Gabriel, and sorry, what?
I believe his name was Phil.
Phil, his name had disappeared off there. Sorry about that, Phil. Thank you both very much for taking part. And none of this seminar could happen without Catherine, who has done everything behind the scene and rescued us from all our catastrophes. So thank you very much, Catherine. And I would also like to thank all of the audience for participating. So thank you very much, everybody. Bye-bye.